Hello, everyone. Welcome back to our channel, U.S. Immigration News. Why immigrants in the U.S. with a green card can be deported. Many people believe that obtaining a U.S. green card guarantees permanent residence without risk of deportation. However, lawful permanent residents can still face deportation under certain circumstances. Violating immigration laws, committing specific crimes, or failing to meet residency requirements can put a green card holder at risk of removal from the United States. Understanding these risks is essential for immigrants to protect their status and remain compliant with U.S. immigration laws. The mass deportation plan that Donald Trump's new government intends to carry out would focus first on undocumented immigrants with criminal records, although the possibility of extending it to all illegal immigrants in the country, whose total population is estimated at tens of millions of people, has also been raised. In this sense, what happens to immigrants who reside legally and permanently in the United States? That is, those who have a green card? That population also numbers in the millions. According to figures from the Department of Homeland Security, from 2014 to 2023, the United States government granted more than 10 million legal permanent residence cards, of which more than 1.1 million were delivered in 2023 alone. So, could those people be at risk of deportation? The short answer is yes, but only under certain conditions. Can green card holders be deported? According to information from the United States government, foreigners with a green card have several rights. They can live permanently in the U.S., work in the country. They are protected by the laws of the United States, the state in which they reside, and local jurisdictions. While foreigners with a green card can live and work permanently in the U.S., they can also be deported. The U.S. government says a person can maintain the rights granted to them by their green card as long as they do not commit any act that would make them deportable or removable under immigration law. The U.S. Citizenship and Immigration Services explains on its website. Elizabeth Uribe, an immigration attorney at Uribe and Uribe APLC, told CNN that a green card is a privilege in the United States, and that one must therefore be careful about what actions are taken to avoid losing legal permanent residency. A person who is a resident should not be deported, unless he or she has a case in immigration court, and the judge determines that he or she no longer has the privilege of being a resident and issues a deportation order. There are certain things that a resident can do to jeopardize that status, Uribe said. Specifically, Section 237 of the United States Immigration and Nationality Act details the reasons that can lead to the deportation of a foreigner, regardless of whether he or she has a green card or not. Causes include individuals who have encouraged, induced, assisted, instigated, or helped someone else to enter the United States illegally, for marital fraud, for aggravated crimes or attempted aggravated crimes. Some of these include bribery of a witness, child pornography, drug trafficking, trafficking and use of firearms, fraud, and falsifying documents, according to the Immigrant Legal Resource Center, for multiple criminal convictions, for escaping an immigration checkpoint, for crimes of domestic violence, stalking and violation of protection order, for crimes against children, for human trafficking, for terrorist activities, for sabotage, conspiracy, or treason and sedition. While having a green card provides stability and many rights, it does not offer absolute protection from deportation. Green card holders must remain aware of the legal and immigration-related pitfalls that could jeopardize their residency. Staying informed, avoiding violations, and seeking legal assistance when needed can help immigrants safeguard their future in the United States.
Hello everyone, welcome back to our channel US Immigration News. We hope you are doing great. Why immigrants in the US with a green card can be deported. Donald Trump's proposed mass deportation plan initially targets undocumented immigrants with a criminal record, though there have been discussions about expanding it to all illegal immigrants, a population estimated in the tens of millions. This raises an important question. Can legal permanent residents, green card holders, also face deportation? While green card holders have the right to live and work permanently in the US, their status is not unconditional. According to US Citizenship and Immigration Services, a person retains their green card privilege only if they do not commit acts that make them deportable under immigration law. From 2014 to 2023, the US government granted over 10 million green cards, including 1.1 million in 2023 alone. Despite their legal status, these individuals can be deported if they violate immigration law. Immigration attorney Elizabeth Uribe explained that a green card is a privilege, not an absolute right, and certain actions can put that privilege at risk. Deportation only occurs after an immigration court case in which a judge determines that the individual no longer qualifies to remain in the country. Section 237 of the Immigration and Nationality Act lists multiple deportable offenses. These include marriage fraud, multiple criminal conviction, aggravated felonies, drug trafficking, domestic violence, human trafficking, terrorism, treason, and other serious crimes. Additionally, additional violations such as encouraging illegal immigration, escaping an immigration checkpoint, or falsifying documents can also result in a deportation. Although having a green card offers security and legal protection, it is not a permanent safeguard. Legal residents must stay informed about immigration laws and avoid actions that could endanger their status. Seeking legal advice when necessary can help green card holders protect their residency and continue their lives in the US without the risk of deportation.